ladies and gentlemen. Daniel Forouzan here with the Schmoozin with Forouzan podcast. Very excited. I have Mr. Thomas Lenz here with us. I've known Tom for many years. He's been very gracious and hospitable. He's done work with me on the West Side Bar Association. He's been on our panels there. I've gone to his law firm's panel. I'm pretty sure I was the only plaintiff's attorney in the audience there. But again, he's been very genuine, and I sincerely appreciate that. I think from the position that Tom has, he also has a lot of information that anyone, plaintiff attorney, defense attorney, in-house counsel, whatever you are, you probably want to listen to Tom because he's been around and, he works at a very reputable law firm. So, Mr. Lenz, how are you today, sir?
Doing well, Daniel. How are you?
I'm pretty happy. It's Friday after all, so no complaints, right?
Absolutely.
Yeah. Do me a favor, just so the audience has an edification here. Tell us who you are, who you work for, what you do. Give us a general idea here.
Glad to. Yes, I'm Tom Lenz. I'm a partner with the Atkinson Andelson law firm. We are a 9-office law firm in California. I am based in Pasadena. I've been here about the last 6 years. I spent, 23, 24 years before that working out of our Cerritos office, which is our headquarters. I'm a partner, and I am the head of the labor relations practice. So when it comes to private sector clients, we advise and represent employers. I am involved in providing advice, representation, training, and so forth. I also teach at USC Gould School of Law. I am what's referred to as an adjunct lecturer. That's a part-time faculty position, and I teach in the ADR program.
Wonderful. Well, look, thank you for taking time to be here today. I know me and my audience both sincerely appreciate it. And something just as an aside, when you reach a certain level of the game, you don't just say where you work. You have to let everyone know how many offices. To have as many offices as Mr. Lenz's, law firm does here. I can call you Tom. I don't like you. To have as many offices as Tom's law firm does, it says something. It says, hey, this is a law firm that's trusted by enough people to grow to that size. And you should take away from that, whoa, maybe I should listen to what Tom has to say today. And that's why, like I said, I'm so excited to have him. Let's get, I know a lot of my audience is plaintiff side. Some are defense side, to be fair. But I think it's worth doing some perspective work here. Let's start with this. What is your biggest, first let's start, what kind of clients do you typically represent? And then secondarily, what would you say is your biggest responsibility to those clients?
I work with employers, and in a variety of industries. I work with nonprofits as well and trade associations. So I would say that, they range in size, they range in goals and perspectives, but I work from the perspective of helping them manage their workforce in a lawful and responsible way. And that's actually morphed a bit, particularly as I've dealt more with trade associations and nonprofits, to where I'm almost more in a general counsel capacity. So I am helping them manage their legal affairs, and to the extent they have claims, lawsuits, issues that might be outside of my specialty area, I am often either working with people in my firm who specialize in an area I don't, or possibly even with outside counsel, to make sure that those organizations, whoever they are, do what it is they need to do. In terms of, what I do, what the clients, want me to do or call upon me to do, it's a variety of things in achieving their goals. I think we take it very seriously that each client has unique goals. They also have unique resources. And I think on the plaintiff side, you see that as well with the situations that come before you. I mean, I was a government lawyer before I joined my firm 30 years ago, and our job was to effectuate the labor laws at the National Labor Relations Board. I did that for several years. At my firm, it's about achieving our respective clients' goals. It may be that they want to get through a particular lawsuit unscathed and fight that to the hilt. It may be that they want to get it resolved ASAP so they can move on and do what they're best at doing, which is making widgets. It could be that they have a number of things they just want to be in compliance with. And Frankly, I love working with the clients that look forward and project out what new laws are coming. What do I need to do to be in compliance? What policies or agreements do I need to modify to adjust to changing times? And we've seen no lack of changing times in the last couple of years. So it's been a real boon for lawyers.
How many KC revisions have you seen insofar as employment law?
I can't even venture to guess. It's been a while.
Okay. Yeah, it's something I just noticed that's been interesting is when I do personal injury and I do employment. And the world of employment is so dynamic compared to personal injury. Personal injury is like duty breach, cause harm. We knew about it since Powell's graph, and here we are today. Not much has changed. The employment, as we're going to get into with Viking Rivers cruises, the 1102.5 attorney fees, various other things, it's a much more dynamic environment. And I think you kind of touched upon this. In California, granted, it's the employment law world is like quicksand or a mudslide. You never know. Tomorrow, there's going to be no such thing as an independent contractor. Today, there's no such thing as PAGA on a multi-plaintiff basis, whatever it might be. What would you say are the things, at least from your perspective, and I'm not trying to delve into your special sauce or get into your attorney-client privilege, but from your perspective, looking forward, what is it that you're concerned about for your clients, and what are your clients concerned about? What would surprise plaintiffs' attorneys to learn? Oh, these employers have considerations too. What might those be, especially given this changing landscape?
I think there are more employers than might be realized that are trying to do the right thing, and that the laws can be so hard to be in full compliance with, particularly when it comes to wage and hour penalties and things of that nature, that you could be out of technical compliance and subject to something that if it's something of broad impact, suddenly becomes a big liability issue. And I think that a lot of employers are trying to do right by their employees. They work with them every day. They may not see them in person every day, given the transition we've experienced to remote work. I think a lot of people are trying to spin back out of that these days, and that's creating frictions too. But I think that people might be surprised at, in many instances, what employers will try in good faith to try to do to accommodate and work with employees. I mean, that being said, there are still disputes that arise, and I like being up front on the issues and trying to prevent disputes from arising. I'm very much a believer that if you make a good faith effort, if you try to communicate and you're not abruptly flinging surprises at people that they're going to not only question, but feel they've been wronged by, you're going to stay out of court. And I think if I can help my clients stay out of court and really focus on what they're in business to do, everybody's better off. And I think I provide greater value than spending time writing pleadings and discovery and stuff like that.
Like talking about perspective, and this is why I love this. It is true. I litigate for a living. And my clients, are individuals. They basically say, "Hey, Daniel, you steer the ship." But for you, your clients are businesses, and maybe they don't want that distraction. I never thought of it that way. As you put it, they should be working on widgets, not dealing with the labor code or whatnot. So I could certainly appreciate that. I think let me expand the question a little further. Would you say, and it's a broad scope question, so please, go on the narrative, give us whatever you think. Would you say that California is hostile to business? And I also want to regulate the question a bit and say, there's small business, there's medium-sized business, and there's large business. Is there a difference there depending on the size of the business?
I think I grew up in Illinois, And I think Illinois has spent its entire existence, at least since I've been alive, trying to be like California.
Mm.
And it's usually a little slower to adopt the rules, but it's considered, I think, one of the more progressive states in terms of rules in the workplace and on other things. I think it was some preparation for coming out here in some ways, but I think it, I'm sure a number of my clients would disagree with me on what I'm about to say.
Mm.
Uh, but I think California takes pride in being a leader. And in, I think, using the law as a tool to reflect and shape the society that the legislature, the governor desires, and that they perceive that the people want. So uh, people are generally resistant to change. If you've been doing something the same way for 10, 20, 50 years and running a business, you don't want Sacramento or Washington, D.C. to tell you to change that. And I can understand why business people might bristle at that. But if you're going to be in the game in California, you need to, keep jumping those hurdles, and you need to keep studying. It's not like you just graduate from school and you've learned everything you're going to learn. You keep learning through your life, through your business, and I think that is an exercise. And by doing that and successfully staying in business in California, I believe you become a model company. I mean, I don't think that there's a lot of companies in other parts of the country that wouldn't make it here because the standards are really high. But the companies that do make it here, I think, are operating at a higher level. And so I'm not sure this is responding exactly as you might envision to your question, but I think that there's a lot of companies out here that think that California is anti-business,
Mm.
and maybe this is not the place for them. If they feel that way, and then they may move to Nevada or Texas, or pick a state that is popular now. Arizona, a lot of people are going to Arizona. But I think that if you like the lifestyle here in California, if you want to live in a vibrant economy such as we are, regardless of what people say about us, it's a great state. It's a great place to be. And so I think that worker protection is important. I think that California has valued that, and the companies that thrive here are going to value that. There may still be disagreements, there may still be struggles that go to court or are resolved outside of court. But I think that you got to up your game if you're going to play in California. If you're going to be a business person, you can't just do what you do in some other state, not to be mentioned. But I think it's a place where what we do, and I tell people, I speak in national conferences from time to time, I tell people what happens here is going to happen to you. It's just a matter of time. So you always have to be watching what happens here. And we're the lab. I think we're basically the lab for labor and employment law.
Very, very interesting perspective. This podcast is already very much so bearing fruit in the direction that I hope. And sometimes I wonder if more cross pollution between plaintiff and defense would be helpful in creating efficiencies. Let me specify the question a little further, though. I hear you. But imagine, maybe a smaller employer, a mom and pop shop, or even up to a medium-sized employer. Say, hey, Tom, we get it. When a large corporation comes to you, they call Tom. Tom takes care of it. You have counsel in your office. You have outside counsel. You'll figure it out. You'll create business solutions for them that comply with the law. Smaller employers who lack the sophistication, taking the question that I just posed, is California hostile to business? If a smaller employer came to you and say, hey, Tom, all that's great, we don't have all those resources. I know it's a tough question, but what would you say to them?
I would say, we need to do the best we can to be in compliance with the law. There are certain basic requirements that, we need to stick with. And I mean, I think to the extent there are any points of friction, that is where you join business associations. That is
Mm.
where you make your point of view known. That's where you present data to, Sacramento, and hopefully that's considered in the rules that are made, or the county, or wherever that is. Um, we thankfully still have a representative government, and people are able to, reach out to the people that represent them, who may or may not listen, but you have that opportunity to have your voice heard. I think that it's important to stay engaged with things like that. I think it's important to show good faith in how you run your business. Um, Even if you are not 100% technically on point in your compliance, I think your good faith efforts, you're doing the best you can. And I think documenting what you do and why you do it is important. And certainly that's the sort of stuff that would come out in litigation. I would fully expect that, if there were any compliance issues, that somebody would want to, dig into those records and see what did you do and why did you do it.
The good faith thing that you bring up is an interesting point. And the reason it's an interesting point is, from my perspective, I have noticed that for someone to call my office and actually want to deliberately sue their employer, former employer, whatever it may be, it's not enough that the employer has broken the law. It seems like the cocktail involves A, a law being broken, but B, either a lack of good faith or outright malice towards the individual. In other words, the cocktail, the two ingredients from my perspective is the law's been broken and someone's been a jerk. And what's interesting to me is you brought up good faith.
Mhm.
I certainly, that certainly rings true to my ears in the plaintiff side, where clients will call me and they're complaining about all these things that are peripherally related to their actual cause of action. They touch upon their cause of action, but they also seem to have, issues, or take grievances with the way their employer went handling certain things, beyond whether or not it was legal, whether or not they did it with a good faith effort to actually resolve the issues, whether or not they did it in a fashion which struck the employee as fair, reasonable under the circumstances. And when you have an employer who acts in an aggressive, malicious, neglectful fashion, that seems to be what instigates my clients to pick up the phone and call me.
Yeah.
So it's interesting to me to hear that when I bring up a small business, your response was a good faith efforts by that small business. I would have to very much so agree, just from my perspective. Speaking about compliance with California law, let's talk about Viking River cruises. Before we do that, I guess it might not hurt just to give a brief primer on PAGA prior to Viking River, and I'll open that to you. What is your take on PAGA? What is your client's take on PAGA before Viking River came out?
Paga scares my clients to death. It's a lawsuit that um, can have massive repercussions. It can involve a broad scope of liability, and when someone is stepping into the shoes of the state of California, they are not your ordinary litigant. So I think it makes it stickier to try to get through those cases, try to get them resolved. But I think that, yeah, anytime you have litigation, which is at a, bet the farm level, hundreds of thousands or millions of dollars, yeah, especially those small to mid-sized businesses, they're going to see that
Mm,
as a threat to their existence,
yeah.
and they want to get those things resolved. And I think, some are going to, have more resources and more gumption to fight them. Yeah, I think that, it's always important to, assess the issues carefully, and narrow them down as best you can to get to, what the real issues are, so that you can try to pursue a resolution. But I think, yeah, these are lawsuits that cause a lot of concern for my clients. And I think that uh, employers have, been looking to arbitration agreements as a way to stay out of court, and that's not been, without controversy. So it leads us up to litigation, such as we've seen with Iskanian and later with Viking River. And yeah, I think that you look at a ruling like that, and it's going to maybe scale back some of the PAGA activity. It's going to, I think, encourage employers to reassess their arbitration agreements, probably to reconfigure them. And whether and when they do that and what they say is of course important. But we'll also see what Sacramento decides to do. And whether California courts have anything further to say about any particular issues left open by the Supreme Court. So yeah, it's a interesting time, and certainly no complete closure as a result of that ruling.
For the few people that don't know what PAGA is, Private Attorney General Act, it allowed plaintiffs' lawyers and their clients to step in the shoes of California government and prosecute certain types of labor claims. There were a lot of claims. There were a lot of different ways to make a claim. There were a lot of different ways to stack the fees associated with claims. And I've been to enough defense side seminars at this point to appreciate the employers and the defense bar's opinion of PAGA, and generally their opinions of arbitration. But let's bring it, before we get into Viking River cruises, let's also talk about arbitration generally, because plaintiffs' attorneys, they say they hate arbitration. You know how it is. It's like, oh, well, the arbitrators are all in the pockets of big business. At least that's what you hear a lot. My experience, I'm not saying that's true. I'm not saying that's not true. I found a lot of arbitrators to actually be very professional. I've been in cases where the arbitrator actually paid them, made the money was something that you might not expect if they were truly in the pocket of some corporation. So I don't have as hostile of a view of arbitration, but I do certainly appreciate civil court. Discovery is more flexible. Certain arbitrators have caps on discovery and various other things. That's my perspective. What about yours and your clients? What does a defense bar and what do your clients think about arbitration?
I think at the end of the day, our clients would rather not be in court or in arbitration. But I think, between the two, they would probably prefer arbitration as much for the efficiency and perceived speed of getting things resolved as I think for the I think the ability to focus in without the I don't know, getting the court involved in every little thing. I think arbitration maybe helps to speed along a dispute, not to skim over necessarily what needs to be addressed, but there are efficiencies there that I think are helped. I think oftentimes employers are looking for closure, employees are looking for recourse and remedies, and I think if it's done right, it can approach the sorts of goals that, I mean, Armendar has talked about factors to I think really try to keep arbitration in line with what courts would do, and processes, remedies, and so forth. And I think that the goal should be to have something that approximates a court proceeding, but with the attendant efficiencies where warranted. I think it's still possible to do that, but there's a lot of distrust for the process. And what I find personally fascinating is at USC, I teach a class on labor arbitration. So arbitration under collective bargaining agreements, where the bargaining power is different. In the labor context, arbitration is there to help resolve disputes that arise involving employment, pay, termination, what have you, under a collective bargaining agreement. And the generally accepted rule is that arbitration is a quid pro quo for a no strike clause. In other words, if you can arbitrate it, you don't walk out. In the employment context, in the non-union, non-collective bargaining agreement scenario, it's not that sort of quid pro quo. It is something that an employer decides to impose. And the phrasing may vary from one employer to another, without that sort of collective bargaining element. So I think there is the potential for really screwy arbitration agreements, for things to be crammed down on people, but it really makes it more of a question. Where are you? What's it say? What dialogue, if any, was there before this was presented to the employee for signature? So it's a real different dynamic, and and certainly it's been called out with skepticism by legislation like AB 51, and we'll see where all that goes. But again, California is going to be the leader on things like this.
With regards to Armendariz, it's an interesting thing to me because, correct me if I'm wrong, that case law says that the claimant is entitled to sufficient discovery. Is that the actual words from the case law?
That sounds right to me.
Okay, yeah. See, and therein is the tension, right? The defense would say, "Hey, you're getting sufficient discovery. I'm the plaintiff. I want infinity discovery."
Yeah.
So, and I get it. When I serve discovery, there's no cost or fee to my client. When you respond to the discovery, there is a cost and fee to your client because they have to hire the lawyers to do the work. So,
Right.
I could certainly appreciate the tension there. I do want to. So let's talk about Viking River Cruises. Finally, a roundabout way to get there. What was your take on that holding?
I think that we're seeing the Supreme Court really, I think, embrace arbitration, embrace what employers are trying to do to efficiently resolve disputes, embrace a national policy favoring arbitration, but also trying to balance that with state law, and trying to provide some accommodation. It's not smooth or or neat. It leaves a lot of questions to be asked and resolved.
Interesting. Let me actually take a step back for a moment, go back to Armendariz for a second, because I have a question about that, or just generally the progeny of case law on arbitration. One of the things that have come up, I forget the case name now, is like RHO versus, and I forget. But one of the things that come up is whether or not a arbitration agreement is reciprocal. And I can see on its face why that would be a criticism. If you have an arbitration agreement that says, "Hey, employee, you have to arbitrate against us, but we have civil rights against you." Yeah, I could see how that could be unconscionable. I could appreciate that. I also wonder how much of a point there is to that, in the sense that, is there ever a time where an employer wants to sue an employee? I mean, from your perspective, does that happen very often?
It does, but honestly, what are you going to get out of it? That's the value proposition. Yeah, I'll gladly, bill somebody my hourly rate to prepare something if there's a claim with merit. But if the guy doesn't, have the ability to pay a judgment, is that worth it? I mean, I think that that's that almost verges on malevolence in some instances, where somebody wants to grind an employee down unless there's a good faith claim. And if somebody has been using company resources to set up their own independent business to compete with their employer, or stealing trade secrets, doing things where you've got some clear tangible value to whatever the damage is. But if you're suing somebody for taking a bundle of paper or something like that, and it's $5, but you're doing it for the principle of it, really, that's not the sort of thing that Yeah, I mean, some folks will take that case, but that's not the kind of case I want to take.
I appreciate that. Viking Rivers Cruises, how does this change the landscape going forward?
I think, in the eyes of the employers that I'm working with, it's like, yeah, okay, this ruling is out there. Is your arbitration agreement going to be appropriate? Is it, do you need to modify it? Do you need to yeah, do other things? Message your employees in terms of, you know, what what you're doing, and not necessarily speaking about the ruling, but to say to the clients and to their management team, we need to, like we do with so many other legal issues, need to make sure that what we are doing, what we are saying, is legally compliant and as enforceable as possible. Because most employers are going to want to get as many issues as they can out of court in a lawful way.
And I don't mean to jump into again your client's privacy or privilege, but I can only imagine. And for those who don't know, and correct me if I don't have the holding totally down. Much of what I do, by the way, in the world of employment, it's on the discrimination side, not so much the wage and hour side. So correct me if I don't have this correct. But Viking Rivers Cruises basically says you can arbitrate your way out of pocket, correct?
It provides some leeway to do that.
Okay. So, I mean, look, I assume employers found that to be a victory. Is that, I don't even know if they're popping champagne or what's going on.
I have seen mixed reactions from people.
Huh.
Yeah, and some people are happy about it. Some people think that it really didn't go far enough.
Of course.
And yeah, and I mean, of course, how often does somebody get a judgment from a court that they are 100% satisfied with? There's often something in there that it could be a finding, it could be an outcome, but it's anytime you're relying upon the judgment of others, it could go any number of ways.
But you're not finding, and again, I'm not trying to dig too deep here. I understand your clients want to maintain their confidences, but broad strokes, there's
Yeah.
no one saying their employers aren't saying we want less arbitration. They're saying we want more arbitration.
That's correct. Yeah,
Okay.
and they see it as risk management. They see it as staying out of court, because you never know what a jury is going to decide.
Yeah.
And I think they see it as a way to try to manage those risks in a legally compliant way.
Yeah, it's an interesting thing. Not only, from the plaintiff's perspective, you lose the jury, and that's under, it's not always what we want. But moreover, especially what bothers me, since so many cases settle before trial or arbitration, what I find with arbitration is you're somewhat hamstrung, I feel like, as a plaintiff. My practice is discovery heavy. It's not because I'm trying to make a nightmare for anyone. It's just I have obsessive compulsive disorder. I'm anal retentive, and I operate from a place of paranoia where I have to overturn a lot of stones. And I find under the context of arbitration, that's a little bit more difficult. Sometimes I have to explain to the arbitrator why I want to serve X many more ROGs or X many more RFPs, or why I need to take another 3 depots, even though I've already taken 4. I've never had an arbitrator not offer me the leeway, but even the fact that I have to ask for it sometimes because we've gone beyond whatever the JAMS rules are or whatever it might be. I think they have 40 SROGs or something like that. Even the fact that I have to ask for it, granted, the arbitrator will probably allow me to do more discovery. Even the fact that I have to ask for it is not only a hurdle, but a mental thing that I have to take in mind when I draft my initial discovery, which is, there's a chance this arbitrator might not allow me to ask for more discovery here. I doubt it. So, from the plaintiff's perspective, I see why a plaintiff whose job it is to uncover the story and the defense whose job it is to protect the castle, I can certainly understand why plaintiff's attorneys, myself included, are somewhat adverse, if not completely adverse, to arbitration. But hey, the law is the law, and as the court rules, so we operate, and that's that.
And I think another thing that sticks out to me is arbitration being a creature of contract. your rights of appeal that you would have in court, they are not there in arbitration. If you want to challenge an adverse ruling, you're dealing with a bunch of different standards, and I think that that goes both ways. I've been on the losing end of arbitration. I've been on the winning end of arbitration, and I think that certainly there's an element of closure when you have a difficult standard of review, but yeah, that's not always the best outcome. So I think that that's something employers need to be reminded as well. I mean, if you get a bad result, if you are found to have wrongfully terminated somebody, you're not going to be able to just fire off an appeal and get that uh, you know resolved at a higher level. It doesn't always work that way.
It's an interesting perspective. I it didn't cross my mind. Hey, maybe the defense side is not so hot on the arbitrator's ruling, and now they have limited recourse there. Again, why I love perspective, why I love having conversations with defense side, and having that exchange, I think is very fruitful. At least it has been for me. A lot of my mentors, a lot of people who I associate with professionally are from the other side of the aisle, and I find nothing to be more enlightening. Now, part of the reason I say this is there are so many, and maybe we'll get into this part of the conversation. I mean, I just came back from CALA a couple of weeks ago. There is a lot of plaintiff side, especially in the world of personal injury, a lot of plaintiff side MCLE seminars, things of that nature. And, occasionally a defense attorney will be at those things. There was actually a defense attorney at CALA, which was very nice. He gave some interesting insights. He gave some information that was worthwhile. But I do wonder just the approach that I'm taking, where it's actual integration between plaintiff perspective and defense perspective. I personally think it's very helpful. Again, for the thousandth time, thank you for coming on the podcast. Labor Code 1102.5.
Actually, if I
So,
can comment on what you just said before we go to that, I have really valued that interaction over the years, because I think that perspective, as you've described, is very important. There's a couple of organizations that I've been involved in pretty deeply where that's come to play. On the labor relations side, it's the LIRA organization, where you have unions, employers, neutrals, all gathering, over topics and discussion and dinner, and that's good. But the labor and employment law section of the California Labor and Employment Law section of the California Lawyers Association. I'm the past chair of that, and we have had participation from really every type of attorney that handles workplace issues, as well as neutrals, and we get people from across the state. I think that diversity of perspective is good. But yeah, you're absolutely right, because there's a big failure to listen to each other. I think in society today, I think to be successful in this field, you will benefit from listening, and whatever side you represent. I think that being in those environments, I think, and being a little more cognizant of what is going on and how other people see things is important.
In the PI courts, they have come up with this thing. God, I can't remember the name. I've never used it. I don't ever see myself using it, but it's like a variation on an MSC, where the court hires a plaintiff's attorney and a defense attorney to mediate a case through the court. And I remember it had some kind of a name. And I think the reason for this is there's just so many PI cases, so many of these auto accident cases. And truly, I think PI is at a point. Obviously, one person's broken arm is not another person's arm amputation. Those are two horrible injuries, one being, life debilitating, arguably. But there is a degree of standardization to the way I feel law is practiced in personal injury, which enables that architecture. I don't know how busy the employment courts are. I don't get the sense they're nearly as busy as the courts that I'm in for personal injury, or the PI hub, for example, in downtown. And so I'm not even sure there would be a need for this variation on MSC where there's a defense attorney and a plaintiff attorney. By the way, just to be clear, neutral defense attorney, neutral plaintiff's attorney. So in other words, for those of you who aren't aware of this program, you have a case, you have a PI case in the hub in Los Angeles, in downtown Los Angeles, and they send you to this MSC type of program, and you're assigned a neutral third-party plaintiff attorney and a neutral third-party defense attorney. And those two neutral attorneys work with both parties in order to resolve the case without the need for full-blown mediation, which would be significantly more costly, I'm sure. But do you see a value in that? Forget PI. Do you see a value for that in employment? And if not, why not?
I absolutely do. I think that the number of workplace disputes is not declining in my view. We continue to take in new cases across the state for a variety of clients, small and large, and the cases just aren't going away. And I think especially with the pandemic and the courts getting backed up, and that there needs to be ways to try to work things out. I think there needs to be options to try to find common ground and resolve these issues. So frequently, you have people who are bringing litigation, and maybe they don't want to leave their employer. Maybe they want to continue to work there. And hopefully there's a way it can be resolved and people can continue to be employed. I like to, especially at a time where many of my clients are complaining about a skill shortage and a difficulty finding good people. I like the idea of preserving employment relationships that are working. And if there's a way to, resolve a dispute, and it may not be, just a particular cookie cutter model of mediation, or a specific model of arbitration even. I think, it pays to continue to think about things, because whether we like it or not, the world's going to keep changing. And I think our creativity as lawyers is something that maybe we don't tap into enough.
Oh, fair enough. Fair enough. Labor Code 1102.5. So correct me if I'm wrong, but the statutes have been changed such that now there are attorney fees associated with a whistleblower claim. Is that correct?
Yeah.
Okay. So I'm going to ask the obvious question. How do you and your clients feel about that?
No, our clients figure there's greater risk in getting sued if they screw up. So I think the exposure increases, and it makes it that much more important not to do that.
Yeah, I can appreciate that, certainly. I like 1102.5 with attorney fees. There are a lot of circumstances that, majority of my employment cases are going to be sexual harassment. That's just the majority of what I do. A lot of clients in the entertainment industry, usually young women being abused. But sometimes there are elements of that. Sometimes there are elements of that where it's not just a form of gender discrimination, but there is a hostility espoused to the employee who happens to actually be telling the employer something worth their while, and they're ignored. And I have a case right now. It's a medical disability case. Guy comes back post-cancer treatment. I'm sure they eventually fire him, and blah, blah, blah. So, there are situations where it almost feels like some of the hostility that was based on the individual's identity bleeds into a situation where, hey, the same person who you're upset with because of whatever protected activity they participated in, whether it's leave, whether it's making a complaint, but moreover, maybe they bring up something related to the employment that's tangentially or peripherally related to discrimination claims. And I think that happens. I think when you is a human being who already dislikes an employee for whatever reason, oh, that employee filed a grievance and we don't like them. Oh, now they're telling us that this is going wrong in this department and we're doing the regulations incorrectly. Who do they think they are? I see a potential there where outright discrimination can bleed into retaliation based on just saying, hey, we're not filing regulations. And I can see it going back and forth. Obviously, as a plaintiff's attorney, I love it. I actually have literally am benefiting from that statute as we speak, or the update to the statute in a case that I filed this year. So it's just an interesting thing to me, especially how the law keeps changing. Let's, in the very little time that I have left here, let's shoot back. I know it's an older case, Dynamics. Mostly, I mean, I I would it would be bad if I'm mostly curious about your take in terms of something that I've had on my mind, instead of not just being an employee and independent contractor, but a third option that's maybe a bit more contemporary and takes the gig economy into consideration. Dying to ask that question. However, I got you on the podcast. Be crazy if I don't ask you. What is your and your client's take on Dynamics?
I think that our clients are, I think, somewhat amazed that independent contractor status is so demonized by the law. But they are doing what they can to adjust. It's different for different industries, different types of companies, and like we discussed a little earlier, change is hard, and I think that some companies are going to be more embracing of change than others. So I think that you know the companies that are wanting to be compliant, that are really aggressive about that, and wanting to reduce their risks. They're going to be making changes. They're going to be reclassifying people as employees. They're going to be modifying the paperwork and doing all. I mean, gosh, there's so many different issues in the employment context that are triggered by this issue of misclassification. It's wage hour, benefits, workers' comp, payroll tax, labor rights, the right to organize a labor union. It's just so many different things, and I'm sure I'm leaving things out. But yeah, you've got to be looking at this multifaceted thing. It's just that there's a lot of different potential exposures. So I think when you walk through that with clients I work with, they're like, "Oh, geez, I don't want to be doing that. I want to make things right." So I'm again making widgets rather than defending lawsuits. We love the work, but I think we know our clients are better off if they're able to focus on the reason why they got into business in the first place.
Fair enough. Let me ask you the question that's been itching. Um, I heard Judge Brazil, I believe is how you pronounce his last name, a couple of years ago when he was still the presiding judge at Los Angeles Superior, discussing dynamics. And he said, one of the things we're talking about is introducing a third category somewhere in between employee and independent. I thought to myself, geez, that sounds remarkably reasonable.
Mhm.
So I guess we'll never see it happen. I haven't heard anything since then. Um, but I take a look at gig economy. I take a look at rideshare apps. I take a look at the fact that people are allowed to set their own schedule, and there are various other things that might suggest that they're independent contractors. And then I also look at just the way things are structured, ultimately who they're paid by, how they're paid, various other things like, well, this also has a feeling of employment to it. And I have my subjective opinion whether rideshare people are ultimately employees or independent contractors. But the problem is, my subjective opinion about that is funneled into one of two categories, neither of which I'm completely sure belong.
Yeah.
So I don't know. How do you feel about that? What's your take on a third classification?
I think a third classification is uh, interesting. I mean, I think that was approached with Prop 22, and certainly got a lot of pushback. It succeeded, but I think that there's a lot of people upset about that outcome. I know that there's a lot of lawyers on the plaintiff side that are upset about it. There's a lot of labor unions that are upset about it, and I think, I mean, certainly change, is difficult, like we talked about. I think there's going to be a lot of resistance before anything like that ever happens. And one of the things that jumps out for me is that these are issues that are regulated by not only state law but federal law. And you've got Department of Labor changing the independent contractor standard. You've got the state, that could conceivably do that. I mean, we've had AB5, we've had modifications to AB5, we've had Prop 22, all in the wake of dynamics. And there's labor law reform pending on Capitol Hill right now. It's called the Protecting the Right to Organize Act, also known as the PRO Act. I think that's the very first thing substantively in that statute or proposed statute would be to adopt the ABC test.
Interesting.
That would be national, but it doesn't have the exemptions of AB5. So you could conceivably have a federal standard that is tougher than the state standard. And so it's just really a weird, wobbly situation where the legal standards continue to evolve. And I think for a third standard to be viable, you would need to have some conceptual consistency between state and federal, some buy-in on concepts. I'm not sure that what my clients would want would be anywhere near what the plaintiff's bar or labor would want. So that's a tough one. I think that Prop 22 is, it's narrow in its application, but I think it's very much an effort. Whether it was a good effort or a bad effort, I'll leave that to people's judgment. But it was an effort to find a middle ground, and I mean it's certainly not been without some real upset. So I think it'll continue to be debated. It's probably in that realm of, should we have a third political party in the United States? But I don't know that you'll have one that competes with the main two ideas of.
Yeah. I feel sometimes where there is uncertainty, that simply indicates that lawyers have job security, because who else to navigate these treacherous waters than
Exactly.
Yeah, it's an interesting thing how that works. It's, what is the definition of reasonable? Well, that's how attorneys get paid.
Exactly.
Yeah. Tom, it's been about an hour. I've taken a lot of your time. I know you're a busy guy. I appreciate it. Before I let you go, I always ask at the very end, anything that in particular you want to say to the audience before we wrap up today?
I really appreciate the opportunity to appear on the podcast, Daniel, and I've always valued the opportunity to talk about these issues, because I think that it's by dialogue that things get worked out. I don't think that litigation provides a solution that everybody's happy with. I don't think people necessarily achieve, what it is they set out to achieve 100% of that. I mean, same with bargaining and negotiation of different things. But I would say that to the extent that people can work together, particularly on workplace issues, I think the better off people will be in the end. Certainly, there's going to be intractable parties and difficult issues that arise. But the more we dialogue and try to understand each other, I think the more we narrow the potential disputes that are out there, and I think maybe educate each other along the way. So I really value what you and other plaintiff side lawyers have to say, and that's information that helps me process and advise my client, because I don't think you can be successful in this line of work without having an understanding of why something is happening, why someone is upset about a situation, and how to avoid that for the future. Because maybe my client screwed up massively in a particular case. If we learn from that and they stay in business and know not to do it again, know how to do something better, I think there's something to be learned from that, and that's a positive. So there's ways to look at these issues, ways to spin them, And I don't think that, fire and brimstone, coming from both sides is, a recipe for long-term success.
Fair enough. You win bees with honey, right?
Exactly.
Yeah, I understand. Tom, thank you for taking time out of your week to spend it with us and the audience. Sincerely appreciate you having on. Look forward to the next time I see you in person, sir.
Absolutely. Please reach out.